Alex here with a legal nuts and bolts video on attorney fees and costs. This will be a replacement video. In this situation, it's more important because the videos that I'm referencing for replacement, one of them especially, is outdated. And I've learned my lesson. Those were videos very early in the channel. I don't mention specific statutes and case law anymore because I've realized that that actually can, and in this particular case, it did change. So it's really going to be a video that is going to show my viewers how convoluted this topic is and how there's so many different angles and moving parts to it. And I know that it's probably going to frustrate people to not get a specific answer to their question on this topic. But what I do hope happens is that people see it is an incredibly important thing to look into. High conflict child custody case or not. If you don't, in fact, you have to watch this to the end. If you're in a high conflict child custody case, if you don't, you will suffer the consequences. It's one of the things that was a huge thorn in my side for the entire 8 years of self-representation. I can't imagine a single state out of all 50 states where this is not an issue. If you're in a state where you've just never had this brought up, please post it down in the comments below because that would be shocking to me. As far as I know, every single state has statutes in place to allow the imposition of attorney fee and cost awards in child custody cases. You just have to watch this video so that you know what to expect and what to look into. It's also, I think, very frustrating and in some ways infuriating for people who are representing themselves in family court because most of these people are going to family court to get some kind of relief for their child. They're having to do research on statutes, rules, and case law with regards to the issue that is important to them and their child, only to find out that they're going to have to put like 20, 30, 40, 50 hours of research into something that most likely they don't care about. Money, statutes, rules, and case law, to find out how exactly their opponent can go about breaking their financial back, crippling them financially, because if they don't do it, it's going to happen to them. And in some situations, there's almost nothing you can do. In other situations, there's a whole lot you can do. And I talk about this in the video Giving Up. The ability of the opponent's attorney to financially annihilate you is 100% for sure a factor in the video Giving Up. It just is. So it's one of those things that I think, as I mentioned earlier, it's frustrating and infuriating. People don't want to spend time doing research on this stuff anyway, and to find out they have to do research on something that they don't care that much about just adds to an already annoyed / angry parent. So the next thing I want to mention is the actual videos being replaced. The titles are Attorney Fees and Costs, Defend Against Attorney Fees, and Attorney Fee Equalization. Next thing I want to mention is attorneys are ruthless. You're going to want to blame them. You're going to hate them for trying to get attorney fees out of you. That's their job. They are ruthless about it. They have to be. I talk about why even their clients expect this. I talk about this in the video Win at All Costs. People who hire attorneys expect their attorney to be ruthless. They just do. They already hate that they're in court. They have to pay thousands of dollars for their attorney. They expect their attorney to win at all costs. I talk about that in that video. I explain why. If you're going to blame anyone, some blame, I guess, would go on the judges. Most of the blame, for sure, goes to the legislature. They can totally fix this problem. It's completely within their power to do so, and they don't. I used to think it was because the Family Bench Bar was some kind of super powerful organization. Now I don't think so anymore. I think that it's just there's a power vacuum there. There isn't another special interest group that's fighting against them on this issue. Nobody's opposing them. And so it's just them asking the legislature for more ways to get attorney fees. And the legislature really is just hearing one voice. And so they go along with it for the most part. Until there is some other special interest group or lobby that can compete with them, you're just going to continue to see this problem get worse and worse. The difference between attorney fees and costs is important. As far as I know, all of the states have a distinction. Maybe I'm wrong. Again, post it in the comments if I am. In Nevada, attorney fees are what your actual lawyer is charging for his time to do their research, to show up in court, and to argue. Costs are different. Costs have nothing to do with your attorney's time. They have to do with you having to litigate the case. So the filing fee is a cost, for example. Sometimes the copies that you had to make to file the papers themselves, sometimes the cost of mailing and postage, sometimes the cost of sending a service processor. I know that there is a contention on the research like programs. I guess Westlaw. There is some case law that does not allow it, and I'm sure that there is other states that do allow them, to recover the costs of using those computer programs. It really is going to come down to statutes, rules, and case law. The reason why, in a nutshell, is different for both attorney fees and costs. For attorney fees, there is case law from way back in the beginning of America. And they call it the American rule. And they mention that the colonists' distrust of lawyers and their specific desire to depart from England's policy of giving attorney fees to the winning side is why the American rule says that you do not just get to recover attorney fees because you won. It goes a little bit more into why, but the point that I have seen made by the judiciary is the only way you're going to recover attorney fees is because a specific statute or a specific case rule or a contract says so. There's no general principle of fairness, nothing like that. Common law, if it was in England, it was specifically rejected by the American colonists. And so that's just what you have to look for to recover attorney fees. Attorneys know this. And guess what? The legislatures and the judges who have promulgated court rules have done precisely that. They've created a bunch of statutes that allow you to recover attorney fees, and there are also court rules that allow the same. So you have to find them to figure out how exactly can these attorneys take your money. The other thing is costs for a different reason. So what I have seen from at least Nevada case law, they use this word derogation. They say that costs are in derogation of the common law. And because of that, I'm not fully sure what it means. What I do know is that because costs are in derogation of the common law, same thing. You can only recover costs where specifically allowed by statute or a court rule or a contract. So that's really the beginning. That's the foundation of where all of this power comes from. It's not general principles of overarching fairness and ethics and morality. I talk about why generally that doesn't work in the video, fairness versus the law, but more so on this particular issue. It's not going to be about fairness or ethics, morality, or anything like that. It's going to be because a statute said so, because a court rule said so, because your contract said so. And so it's extremely important that you find out exactly where they can get these kinds of awards from you. And like I said in the very beginning of the video, you're going to hate it. You're going to hate it because that's not why you're putting yourself through all the stress of going to court. Probably a lot of you didn't even think that this was an issue. You're going to find out it's a huge issue. I probably put more than 100 hours into dealing with this in my child custody case, which is mind-blowing, I'm sure, for a lot of you, because you're thinking, how do I protect my kid? You're not thinking, how do I do all this research on something that I really don't care about? Well, they're going to force you to care about it when they start taking your money. Just start right from the beginning so you know what to expect. I don't know if I mentioned this, but it will 100% for sure have an impact on the thought processes that I discuss in the video Giving Up. I talk about that in the video Giving Up. That's one of the things that and please watch the video, it's more complicated than it sounds. One of the things that you have to take into consideration is the ability of that opponent, the opponent's attorney, to break your financial back, to financially annihilate you. That matters. That absolutely does matter. If they can do that versus if they can't do that, it will have an impact on your decision to bring issues to the court. It just plain will. I guess let's go into this. We're going to bounce around here because there's just a lot to this, guys. Maybe costs are easier. Maybe I'll start with costs. Costs you can recover whether you're an attorney or not. If you're representing yourself, you can recover costs. You just can. It has nothing to do with research or anything like that. I went over some of the different examples and I didn't explain why. I think I mentioned maybes. The reason why is because they're going to be in the statutes. The definition of what costs are and what's going to be included in costs is defined in the statutes. It is. So you have to look into those specific definitions, because that will explain what you can tax as a cost and what you can't. There is also case law interpreting all that stuff, and there is also ways to object and ways to actually claim the costs. I've seen some people do it by motion. I'm not sure if that's proper, because there are laws, at least in Nevada, that mention specifically that you have to file a memorandum of costs. Or they sometimes call it a bill of costs. There may be a difference between the two. You have to do your research and find out what that difference is. If it's not a motion, then, well, how do you challenge it via due process? Well, there's another statute I've seen that says if somebody files a bill of costs / memorandum of costs and you don't agree, then you file a motion to retax, which will probably trigger an opposition, a reply, and a hearing. If you want to learn more about that, you can watch the video motions. If you want to learn more about hearings, you can watch the video hearings. But there is a process, there is a procedure. You have to comply with it strictly, and there are time limits on not only when you can file the bill or memorandum, but also on when you can oppose them. There are time limits. You have to comply with them. You have to do your research on this. It is not uncommon at all for attorneys to try and claim costs that are outside the boundaries of costs. It's not uncommon for judges to make mistakes, oopsie, and order you to pay costs you shouldn't have had to pay, and there's nothing you can do because you didn't comply with the deadline, you didn't object, and now you can't appeal. This happens. You have to do your research on this, because if not, you will be taken advantage of. Let's see. I think that's really all that I have when it comes to costs. They're not as complicated as attorney fees. There are way more cases and way more statutes on the recovery of attorney fees. And they vary wildly from one different area to the next. So, and there's also limits there's caps sometimes in some places. So, for example, in the justice courts in Nevada, this is just an example, this can change. There are the justice court rules of civil procedure, and they say that there's a cap, I think, last I checked, was $3,000. You make sure you do your own checking. That can change, that can disappear. There can be other things out there that I don't know about. Small claims, which is a specific action within the justice courts. There are 3 different actions in the justice courts that can be filed. One of them is a small claims action. There's statutes saying that you can't recover small claim or attorney fees in a small claims action. It's just banned. Then there's exceptions to that particular exception, which I think, if I remember correctly, shoplifting. You can apparently recover attorney fees if it's a small claims for shoplifting, or if it's an appeal. If you're appealing from a small claims action in the justice courts to the district court, apparently you can recover attorney fees, but there's a cap of $15, yes, $15, which is maybe they made that back in 1913 or something, where that was actually a lot of money. I don't know, but it's still there. And the Supreme Court of Nevada has case law saying it still applies. I think it's Snyder v. York. Remember, guys, that can change. So just to let you know, yes, this is convoluted. There are rules on the justice courts on how to recover attorney fees. And then there's exceptions, like in the small claims action. And then there's exceptions to the exceptions. Like, you have to check all this stuff, because there is a myriad of statutes, rules, and interpretation on it. It's just one of those things that's constantly at issue and interpreted by the Supreme Court. There's even confusing statutes where the justice courts refer to attorney fees as costs. Everything that I just said is contrary to that, but a statute can override these kind of general rules, and they refer to in the justice courts, in the specific statutes refer to recovery of attorney fees as costs, which makes things even more confusing. But I'm just giving you guys sort of an alert or an alarm to go out and look into this stuff. I'm going to continue to say this throughout the video, because you just have to do it. Or, like I said, you will find them taking all of your money and making you so poor that you can't come back to court. And if you're dealing with a child custody issue, now your child isn't being protected. So that's at the lower court level. There's district court rules that they don't make it any simpler. There are, as far as I know, sanction statutes at the district court level that I think actually apply in the justice courts too, but they explain that you can recover attorney fees if you can show that the other side is litigating against you with no intent but just to annoy and harass you. That's what they're trying to do. And there's case law on what exactly that means. I mean, from what I have seen, the case law there specifically says that their litigiousness and them losing is not enough. You have to go beyond that and show how are they harassing you. But then there are other statutes that in a claim for money damages, a lawsuit for money, if it's under a certain threshold, I think it's 20K, again, guys, it can change, then the court has the discretion to just award attorney fees. If it's over, you would think that the court can't do it, but then there's other ways people can go around that. For example, offer of judgment stuff. And I talk about that in the video, mediation and settlement. Please watch the video. An offer of judgment is another way in a different statutory scheme for people to recover attorney fees, even though what I just mentioned would make it seem like they don't apply. I talk about this in the video, statutory construction, that sometimes there are different statutory schemes that contradict each other. And in the video, statutory construction, it goes into the rules for how judges are supposed to interpret these conflicting schemes. And generally, the rule is that they have to kind of harmonize, and they have to reach the intention of the legislature by coming up with a way to apply those statutes in a way that you can make sense of both schemes. So again, tons and tons of research you will have to do. If you're in a child custody case, too bad, you're going to still have to do it, because if you don't, they're going to go after you. You know what, whether you do or don't, they're going to go after you. They went after me 7 different times. 5 of the times I was able to fend off the request for attorney fees. 2 times I lost. One of those 2 times I filed an appeal, and 1, which meant that the order against me was reversed. The other time I cut a deal. So it's hard. It's very hard to confront the attorneys on this, and that's because of the climate that the legislature has set up. But it can be done, as I've just described to you. I was able to do it 6 because of the reversal, 6 out of the 7 times. And then the 7th time I was able to get a great settlement. I settled for less than half. I think it was, I don't know, around 1/5 or 1/6 the amount they requested. They weren't happy about it, but that's just, they took the deal. Be careful if you're in family court and the other side is or even your own attorney is suggesting agreeing to attorney fees as a prevailing, attorney fee awards as a prevailing party. Some attorneys will do this. It will become your worst nightmare, unless you're rich. If both sides are rich, it's fine. It makes sense, fine, go with it. But if both sides are poor, or if one side is rich and the other side is poor, really bad idea. Because the side that's poor in a high conflict child custody case will much more quickly find themselves unable to afford counsel. And they will go into court representing themselves with a huge disadvantage, where the other side, who has an attorney, gets money every time they win, and they, who are poor, they can win, doesn't matter, they're not going to get fees. It's absolutely going to play into the strategy of the other side. They will for sure exploit it. So be careful. As far as I know, a judge cannot force you into a contract. So if a judge just over your objection enters that into the order, you should be able to get that overturned on appeal. The family court judges don't always understand this, so just plan for it. The reason why is a combination of high conflict incompetence and end of filings is not end of abuse. Those are 2 different video topics you should watch. High conflict incompetence explains that judges in these family court cases most of the time assume that the litigious person is the high conflict person. They don't understand that there are cases where the high conflict person is not the filer. They are instead violating the court's orders and abusing and neglecting the child and not filing anything. And the protective parent is the filer. It does happen. Most of the judges do not understand this. They see the parent as the parent who is filing paperwork. They will usually see that parent as a problem. I think it's because subconsciously they don't want to do all the extra work. And so it's easy for their brain to sort of twist reality as a judge into thinking, this person's filing too much stuff, they must be the bad guy. That's only going to apply if they're unrepresented. If they have an attorney, oftentimes the judges think, well, that's the attorney, that's their job. It's their job to file a bunch of papers. Whether they have merit or not, they're making their money. When a non-attorney is doing it, they will usually target the non-attorney. I talk about this in the video, self-representation bias. So please watch those 3 videos. It'll help you understand why the judges don't understand what they're doing and are imposing these monetary sanctions against you, thinking in their head that they are justified. So again, self-representation bias, high conflict incompetence, and end of filings is not end of abuse. That's another video. I didn't talk about it a second ago. A lot of the family court judges think that once the filings stop, the abuse stops. They just assume that since nobody is coming back to court, that everything is working out now. And so in their head, they have to get you to stop filing things because then magically everything's okay. They don't realize that what they're doing is they're bullying people into not filing paperwork, and that they're just giving up, and that they're just allowing their child to be abused into oblivion because they feel that not only does the court not care, but the court's also going to break their financial back when they try to get relief. So trying to understand why the judges make the mistakes is very helpful for you to then kind of make a presentation to them that kind of jars them awake, that pulls them out of making the mistakes that they ordinarily would make. Harassment and vexatious statutes, I just wanted to mention kind of as a side note. I don't have any problem with those. They make sense. They do not allow an award just because you lost. It's the other side has to go much further, and they have to say, look, the person lost and it was meritless, and that even then that's still not enough. They have to go even further and say, not only did they lose, not only is it meritless, but they specifically did this just to annoy and vexate my client, just to annoy and vex my client. And if they can show all of those things, then they can recover attorney fees. I think in child custody cases and in high conflict child custody cases, that does make sense. Those are great statutes. They should stay. Those are good statutes that actually can be used against a high conflict parent. And they, as far as I know, require evidentiary support. So I just wanted to mention, I'm not against attorney fees all the time, anytime. I'm just against attorney fees in high conflict child custody cases to the prevailing party or as an equalizer. And I'm going to go, well, I was going to say that later. I was going to explain later as to why I think that. But instead, what I'll do is I'll direct people to the video discretion. The video discretion describes the problem of discretion, which makes it extraordinarily difficult to predict the outcomes in these cases and also ties into self-representation bias. For different reasons. This stuff goes deep, guys, but it will impact your life. So you have to figure out how all of it works before you find yourself deprived of all your money. You have to figure it out ahead of time so that you can minimize the damage that the judiciary and the opponent's attorney can do to you. But yes, in areas of the law where the outcome is more predictable, it makes sense that attorney fees are awarded to the prevailing party. It makes sense. In areas of the law where the outcome is completely random or very difficult to predict or based on the personality of the judge, which usually ties into their relationships with the attorney, which you have none because you didn't go to law school with them, all of that's discussed in discretion. And because of the problem of discretion, it makes very little sense to have prevailing party statutes in those types of cases because it's such a crapshoot. In the other types of cases, again, that makes sense to me. Money damage lawsuits, areas of the law where statutes are going to control the outcomes a lot more firmly and you can predict what's going to happen. Those actually make sense as to awarding attorney fees to the prevailing party. It really does. But family court, not right now. Too much of it is a gray area. And all it ends up being, in my opinion, is a mechanism that is abused by the family court attorneys to rip off the self-represented parties. And the reason I say that is because oftentimes I've seen that when there are two sides, the judge just won't award fees. Why does this happen? So much, guys. You can see that I've got a lot of knowledge on this, or at least let's say experience, because I represented myself. The reason it happens is because the judge feels bad for not the parent who is poor, but rather the parent who is rich. When a person comes into court with an attorney, most likely the judge is going to feel bad that that parent had to spend money on an attorney. They don't seem to understand that this is actually insulting to the person who is too poor to afford an attorney, because if that person could have afforded an attorney, they would have hired one. So they're going into court without an attorney because they are too poor to afford one. And the judge says, you know what? Not only am I going to rule against you, but you're so poor that I'm going to actually make you pay money to the other side that's more wealthy because I feel bad. Guys, I can't even make any sense of it. They're taking money from the person who couldn't afford counsel and making them pay for the counsel that they couldn't afford to the person who was able to afford counsel. If you're not outraged by this, I don't know. I mean, you must not be representing yourself in court. It's completely abusive, but the legislature has allowed it with the statutes. That's exactly what happens, is they say, I'm sorry that you're too poor to hire a lawyer. Pay your ex's lawyer. And they don't seem to understand how outrageous that is, but they do that because the legislature has created statutes that allows them to do it. And so their brain has sort of warped reality to make them feel bad for the rich person because they actually had to pay money for the attorney, instead of thinking, hold on a second, this is not, guys, this is a really tough thing for me to talk about. But I really don't think that the judges are evil. I just think that in their head, they find ways to make sense of what they're doing. And so they don't understand that it's wrong. And this is one of those areas where they really don't understand it. I know that to us, it makes sense. You wouldn't want to make a person who's too poor to afford their own attorney pay for the other person's attorney. That's completely backwards. But in their head, they don't see it that way. They see the rich person as, oh man, that sucks. They had to pay $5,000. Let's make the poor person pay for some of that. So guys, this is just one of the things that is just the reality of the family court system, and it's just there, and it's there. And so you just have to, understanding why the judges do that might help some of you with the paperwork that you put together and the oral arguments that you make. I hope that it does. Trying to understand where they're coming from will hopefully get you to be less shocked and freaked out when it happens to you. I guess I'll talk a little bit about the Brunzel factors. This is probably something that's consistent with all 50 states. There is criteria in Nevada and hopefully in all 50 states on what attorneys can do to substantiate the specific dollar amount they are requesting. As far as I know, these types of cases and this analysis does not go into whether they are or are not entitled to an attorney fee award. Instead, it goes into how much can they get if they are entitled to an attorney fee award. And it goes into a specific list of things that the court must consider before they award attorney fees. There also, at least in Nevada, are cases on family court awards of attorney fees. And at least in Nevada, they are required here to consider the income disparity between the parents. I don't fully 100% understand how they can gauge or measure that, but apparently it's a thing that they have to consider. Hopefully that's a thing that comes up in other states as well. It makes sense to me. I don't know where it's coming from. I just want to let people know that that is yet another thing to do your research on, and to, of course, keep in mind that this stuff can change over time. Getting attorney fees for an attorney who's representing themselves in court. This is going to depend on case law. In Nevada, they can't. In Nevada, there are specific cases that say if you are an attorney, you can get attorney fees if you hire another attorney, but if you choose to represent yourself, no attorney fees. Other states will probably vary. They probably will. Please do your research. Then there's exceptions, or not exceptions. I was going to call it an exception, but more like there are weird situations, I guess we'll call, where it's not even that weird. Okay, let me just explain it. There are situations where an attorney owns a corporation or a LLC or something, a business entity, and they represent their own business entity that they own. In that situation, they can recover attorney fees. And I guess the reason is that they are not acting on their own behalf, but they're acting in the capacity of an attorney for the business entity. There's cases on this that explain why they can do this, but they can do this and they can recover attorney fees because the actual litigant is not them. It's the business entity, whatever it may be. And they're just serving as a licensed attorney for that business entity. It's probably going to frustrate a lot of people. They're going to feel like it's the same thing, but the law doesn't think so. There's nothing you can do, at least in Nevada. They can recover attorney fees. What else was I going to talk about? Oh, I wanted to mention, if you guys wanted to go into the examples of me defending against attorney fees, as I mentioned earlier in this video, I have a series called the My Docket series, specifically the High Conflict Child Custody series. Watch the series from beginning to end. You will see me go toe-to-toe with my ex's attorney and fend off those attorney fee requests most of the time. Then, as I mentioned, there is one time where I lose, but I file an appeal and it's reversed, so I really technically didn't lose because the Supreme Court forced my judge to vacate her order. And then there's another one where I cut a deal. But you'll hopefully get a more three-dimensional understanding of how this is used against you as a weapon if you watch that series, and hopefully those examples help you. Attorney fee equalization. I think I might have glazed over this. I'm going to talk about this a little bit. When it comes to marriage, it makes sense. The reason why is because a husband and wife are married, they have community property, they're sharing the assets, and they're sharing the income that both sides is generating. And there are laws, and I think case law, that allow the judge to equalize the, litigation capability of both spouses prior to even making any kind of award as to who won or who lost and all that stuff. They can just sort of equalize the situation between the husband and wife in these types of cases because to me it makes sense. They really haven't separated yet. And so the court's trying to make them so that they come to court on equal footing with the ability to litigate the issues without one side being, lopsidedly more powerful than the other because maybe the wife is a stay-at-home mom and the husband makes all the money at work, stuff like that. I understand that. There are other statutes, though. They are starting to pop up. And there is one in Nevada. These are insidious. They allow the family court judge to award attorney fees, not because you won or lost, not because you're harassing or not harassing, but just because they want to sort of make it fair for both sides who came to court to litigate an issue. The law that I'm talking about hopefully changes, hopefully is repealed. I don't know if other states have this kind of law in place, but it basically says that in Nevada, at least, and this can change, whenever somebody comes to court on an issue of child custody, the court can order the equalization of attorney fees and also costs. I think with regards to experts and stuff like that. With costs, I guess it kind of makes sense, especially if both sides get to kind of pick out the expert that's going to come to court and testify. With attorney fees, it just ends up being an easier way to abuse a self-represented parent. In my strong opinion, it does. Because now all of the misguided notions, the wrong-headed approaches that the family court judges will take that I mentioned earlier in this video are a whole lot easier to impose upon the poor parent because now they don't have to show that you lost. Now they don't have to show that you came to court with a meritless claim that was unreasonable and that was going to harass or annoy the other parent. Now they can just say, oh, look, there's this new law. I'm going to just equalize the costs. And so what a lot of the judges have been doing is saying, here's a parent who came to court with a lawyer. Here's a parent that's too poor. And they'll make the poor parent pay the attorney fees, at least in part, of the other parent. 100% made the situation way worse. Already there are so many organizations out there that are attacking the multi-billion-dollar industry, the exploitation of attorneys and attorney firms in getting attorney fee awards. And what did the legislature go and do? They made it even easier for the judges to impose attorney fee awards. So they're just throwing gasoline on an already huge fire and making it way worse. Again, guys, I think it's because there isn't anyone up there to speak sense to the legislature on how these laws are actually being applied. Another thing is really the flat out incompetence of the legislature on considering this statute in Nevada, at least, because I say this because I read the transcripts and the legislature discussed certain things at the hearings, which was, we have one parent who really needs help. They need actually to get an attorney and, things are not fair between both sides financially. And then the actual language of the statute, which doesn't say any of that at all. If you actually read the language of the statute, it doesn't discuss the court trying to help a poor parent. It just discusses the court has the discretion to do this without coming up with any boundaries, any limits, any purpose. The law itself does not match the debate that occurred in the legislature. That's what I'm trying to say. If you have a chance, if you're curious, you can go into the Nevada Revised Statutes. You can find the statute that I'm talking about. And you can go into the Assembly Bill, Senate Bill hearings, read what was discussed in the hearings, and read the language of the statute, and you'll see that they're not consistent. So there was discussion at these hearings as to what the purpose of this law was, and then there was a completely different law that was passed that is not matching what was discussed at those hearings. So this is a huge issue that I'm sure is not just in Nevada, and that it is definitely creating a worse situation rather than a better situation. Next thing I wanted to talk about was just because an attorney succeeds on one point for attorney fees does not mean that they succeeded on all of them. There are cases that discuss this. Keep this in mind. So if there are situations where the other attorney is able to win and say that you did harass on this particular issue that was brought to the court, you can still say, fine, I can pay the attorney fees on that one issue, but that I don't have to pay the attorney fees on all of the other issues that I brought to court that actually did have merit. So there is, I think it's Bergman v. Boyce in Nevada. Again, guys, these laws change, so just constantly going to give you that disclaimer that just because I mention a case now does not mean that you go there and stop. You have to go and check, how has this changed? What law was it based on? What laws can change? All that stuff. I think that this is going to really wrap up everything on the issue of attorney fees and costs. If you are representing yourself in court, this is one of the most important things that you can look into, in my opinion. A lot of the judges, because of what I talk about in self-representation bias, want to get rid of people who don't have an attorney. One of the ways that they think they can do this is to punish you financially. They won't say it in court, but they'll come up with a way to punish you financially. So the more knowledge that you have on the issue of attorney fees and costs, the better off that you're going to be. As with my previous videos, feel free to post any questions or comments you have down in the comments below, and I will see you guys next time.